Well, Dan, let's get started. We'll put the purpose slide up there on the screen, and just to note that you've arrived at the National Watershed Coalition Basic Easements for Watershed Projects informational webinar. The purpose is to make sure that we can give you some background, the importance and necessity for easements, basic information regarding developing easements, project operation and maintenance connection with easements, the challenges with easements, and working with our land managers. In just a minute or two, Dan Siebert's going to say a few words, our Executive Director of the National Watershed Coalition. The voice you're listening to is Ray Ledgerwood, moderator for today's webinar. Now, some information regarding the webinar itself. If you're just joining us via the verbal or audio version, I would suggest you'd find a computer, go to www.joingotowebinar.com, www.joingotowebinar.com. Our webinar ID, if you've got a pencil handy, 881-400-267. You'll get a lot more out of the program today if you join us via the computer. So Dan, let's turn it over to you for a few welcoming remarks.
Thanks, Ray. Really excited to have so many people on today and appreciate you taking time to join us for this Easement Basics webinar. Several things. Easements are a very important tool in every watershed project across the country. They're often a misunderstood tool, whether it is by the easement holder or the easement grantor, but we hope to shed some light on that today. Sometimes easements are underutilized, and sometimes we fail to recognize the responsibility that goes with being an easement holder or with giving an easement. But today we're going to take a high-cut view at easements and how they work for project sponsors. And we probably are going to get into an interesting case study or two as we progress through this. But again, we're very excited that you gave some of your valuable time today to join us for this. Our NWC chair, Lisa Knopf Owen, is also on the call today. For those of you that may not have interacted with the Watershed Coalition before, we're a nonprofit 501c3 coalition made up of national, regional, state, and local organizations, associations, and individuals. And we advocate dealing with natural resource problems and issues using the watershed as the planning and implementation unit. With that, how do we operate? How are we governed? Very quickly, Lisa Knopf Owen is our current chair. Rex Isom of Texas is immediate past chair. Our vice chair position is vacant right now. Barb Olgen of Kansas is the secretary treasurer of the National Watershed Coalition. We operate by a steering committee led by members who have elevated to the steering committee, and all of those folks that I just named are the executive board or leadership team for the Watershed Coalition. So what do we do? Well, one thing we do is webinars. We provide and conduct workshops and training sessions, and in this case, with the current situation, we're doing that as a webinar. So we serve as a resource to put sponsors in contact with others that have completed construction or rehabilitation projects so that you can learn from each other. We provide assistance in developing strategies and sources for project funding. We also hold biennial conferences. We develop certain watershed publications, and we maintain a website and a Facebook page, both being places where you can go and find resource materials and catch the latest news about our activities. On our website, you will find announcements of workshops, conferences, webinars, and events. There are fact sheets there that are downloadable, feature articles on watershed projects, videos, and fact sheets on project funding, operation and maintenance, hazard classification changes, dam watch, and other watershed-related subjects. And also, I'd point out that there are membership materials available there if you would like to affiliate with the National Watershed Coalition. We'd love to have you. Our strength is in our members.
Thanks so much, Dan, for those welcoming remarks. And anything to add to your welcome?
No, sir. Turning it back to you, Ray.
Thanks so much, Dan. Just to make note of a few logistics for our webinar, informational webinar today, and it is an informational webinar. All the lines are going to be muted except for our presenters today. You can ask questions though via the web and use the dashboard on your computer. Just to review that with everyone that hasn't had a chance or just joined us, you'll tap the orange arrow at the top right-hand corner of your screen, go down to the questions area, tap that questions area, type your question in, tap send, and we'll receive that here at our station and moderate those questions as we go along. We're going to get to as many of the questions as we can, but we do want to keep the time, concise. So we'll do as much as we can today. Just to note, the presentation is being recorded. So if we do, if you were wondering, but that doesn't give you a license not to check in and make sure that you listen to our speakers today. Feedbacks, welcome, kudos, comments, etc., and even suggestions for other webinars would be welcome. You can send those to my address. I've been sending you emails right along, so you should be able to just respond to any one of those. You'll also receive an evaluation opportunity sent right back to me also. So we welcome that. Dan and I will study those notes that you send back to us. The agenda for today's session includes the opening comments, the agenda and session objective. We're going to turn it over to Janet Stewart in just a bit from the Oklahoma Conservation Commission on easement basics and typical watershed project easement notes. We're going to stop after Janet's presentation and take a few questions and get some responses from Janet in particular before we turn the program over to John Devlin. John's an attorney. You see his logo there, and he's had some experience in easements and successful easements defense, in particular in South Carolina. So we look forward to John's presentation. Stop then and also have some more questions and responses for John. Have some closing remarks and end our webinar at that point. That's our agenda for today. My opportunity to introduce Janet Stewart from the Oklahoma Conservation Commission. We're going to switch the presentation over to Janet so that she can run the slides back and forth. So Janet, let's do a mic check and let's do a check of your slides back and forth. Janet?
Yes, I'm here. Can you hear me?
We're hearing you very loud and clear. We appreciate that. And you're in control of the computer now.
Well, there it goes. Well, thank you for inviting me to speak today. I have been asked to kind of go over some of the basics for easements on watershed projects. I do want to point out that I work with the Oklahoma Conservation Commission and we assist conservation districts. So I may slip and say conservation districts through this presentation, but it's really anybody who is working with easements and dealing with water retention structures. So please keep that in mind. I know that Oklahoma has 2,107 flood control structures that I assist districts with in regards to easements and maintaining those easements. So to start out the presentation, if it'll click over. It's not flipping. There it goes. Okay, I wanted to talk about real property. And what is real property? Well, it's the land and that which is affixed to it or which is incidental or pertinent to it. And we're going to kind of break down that sentence a little bit in the next couple of slides. The next slide is talking about what is land. Land. So land is the solid material, of the earth, whatever it may be made up of. So is it soil, rock, sand, or some other substance? And then what does affixed mean? Because we talked about something needed to be affixed to the land as part of the real property. Well, fixed means that it may have roots like trees or brush, vines, those types of things. Those are attached to the land and become part of the real property, or it could be something that's embedded like walls or things that are permanently resting on the land. So you're talking about buildings and those things that are permanently attached to something permanent like buildings. So your cement and plaster and nails and screws and those types of things is what affixed means, and then what's incidental or pertinent. Something is deemed to be incidental or pertinent to land when it is by right used with the land for its benefit. And the best explanation I have for that is if you had a mine and you had the sluices, the box, the flumes, the hoses, the pipes, the railway tracks, the cars, all those things that go with it, that all becomes part of your real property. So every kind of property which is not real property is considered personal property. And a person who owns property may possess and use it to the exclusion of others. I don't know about all the other states, but I definitely know in Oklahoma, you know, one of the things you'll hear people say is, well, it's my land and I can do what I want. And this is exactly, you know, that concept of it's my property, I possess it, and I get to make the decisions about what happens to that land. So project sponsors. Project sponsors, at least here in Oklahoma, deal with water retention structures, the impoundments of water, installing other works of improvements. And they have done this really in two different ways. One is they have either owned the land, which is really more common if it is also used for city water, municipal use, those types of things, or they have been able to put in those retention structures through an easement, a legal right to use the land, but not owning the land. So one of the things that they use, of course, is an easement. And so what is an easement? If it'll flip over. Well, let's talk about ownership of land first. I guess there are many different types of land ownership, but the most common is fee simple or fee title. So this basically means that the owner of the land, if you own it in fee simple, it has the right to the surface, to everything underneath it. So of course you're talking about oil and gas and minerals, all those mineral rights, and the right to the what's above us. And of course, we are learning more about what that means as we get into drone technology. And then, of course, fee simple is the broadest property interest allowed by law, and it endures until the current holder dies without heirs. So that's a good concept to understand because a lot of people own land in fee simple, but then there are variations in land ownership. Then we get into what is an easement, right? It's a right of one person to go onto the land of another person and make limited use of that land. So for water retention structures, what you're doing is you're getting an easement to go in and construct and build and operate and maintain a water retention structure, but that's the limited use of what you can use that land. You can't go out there and fish on that landowner's property, throw parties on his property or anything like that. It's very limited in the use of that land. In Oklahoma, the costs of repair and maintenance are automatically the duty of the easement holder if there's no agreement to the contrary. So why an easement? A useful and well-established real property legal tool is what an easement is. It's used every day for roads and driveways, utilities. You see it a lot in oil and gas for access roads. So it's a tool that's used quite a bit, and there's different time limits that an easement can run. So it can be temporary. So you're going to temporarily use the land for a purpose that's not going to take very long. Or you can set a length of 5 years, 10 years, 20 years of how long you want that easement to run. And then there's permanent easements, which are perpetual, and we'll talk about that a little bit more. The other thing about an easement that's really important is it's a document that's recorded with the land records, and it runs with the land. And what that does is it provides notice to subsequent landowners that you have that easement and what the uses are, so that if they come in and they're new, they don't know what a water retention structure is, they can go and find the easement in the land records, and they are now put on notice.
So Janet, may I break in here just a little bit?
Yes.
I'm going to do a bit of troubleshooting. This is Ray Ledgerwood, your moderator. I've got two individuals that are having difficulty with the audio. So let's do two things. At your place, Janet, grab a sip of coffee or water or something, and we're going to get right back to you. If you're having that problem with the muted sound that could be at your machine, please check your machine to see if the mute button is on your machine. If it is, then that would cause you not to be able to get the sound today. Now, if it persists, one of the things you can do is just simply go out and come back in again and see if the computers start to talk that way. Doesn't happen all that often, but do want to make sure that we try to get those two folks. And you can call in on your phone. Mary also said that worked for her. So you can call in on your phone, use the audio, go to the audio area of your dashboard, tap phone, go ahead and type that in, and you should be able to join us. So sometimes our computers don't talk, but for the 2 or 3 of you, that was sent. So yeah, anyway, laptops are picky, and to activate your laptop, sometimes you have to unplug your second monitor, do something at your place, and I won't be able to sit there next to you, doggone it, and help you with that. So check the mute button, check your machine. If you need to call in, you can switch between speaker devices on your speaker icon on the dashboard, and then you can also go to the audio versus the phone call. So Janet, thanks for letting me butt in there. My apologies for doing that, but wanted to just help the folks, the few folks, 3 or 4 folks that were having difficulty with the audio. So Janet, back to you. Thanks so much.
Okay, thank you, Ray.
Yeah.
So I wanted to talk now about some of the general language that we see in the easements for water retention structures. I know that in Oklahoma, most of our water retention structures or flood control structures were built based on easements that were acquired in the late 40s, the 50s, 60s, 70s. And there tends to be some reoccurring language that's in all of those. And one of those is that the easement allows for the construction of the water retention structure. It allows for permanent storage of water in the sediment basin. It allows for temporary storage of heavy rains or floodwaters. And then it also allows for access to the dam and for the operation, maintenance, and inspection. And in Oklahoma, operation and maintenance also includes repairs. One of the other things that I will note, and I may bring it up again later, is in the general right of access, we do see problems with that in Oklahoma, because when new people come in and get the property, they don't always want to allow you access. And since access isn't specifically detailed out in those old easements, that does tend to be an issue that we have to address when those issues arise. And then also, a lot of the easements are what we call block easements, where you may have a whole quarter section listed, or the other way that some of them are they're elevation easements. So they're based on elevation in the easement, and then of course you'd have to get the work behind that to show people where the easement lines are. Continuing with those, some of the other issues that show up is in regards to operation and maintenance and inspection. Those are included, but what I have been learning over the years is that many times new landowners come in and they want to know exactly what are the responsibilities as to operation and maintenance. And so those are some things that you need to be thinking about. I know in Oklahoma, we have got some statutory changes that explain more clearly what operation and maintenance means. And that gives some guidance to landowners and to our project sponsors. Of course, we talked about an easement being perpetual. It is common for easements to be of a perpetual nature, especially in Oklahoma here for our flood control structures, which means that it stays with the property irrespective of change of ownership until the project sponsor decides to release that easement. Another thing that you need to think about when you're looking at an easement is what can the landowner do and what can the landowner not do. And some of the things that a landowner cannot do is they cannot interfere with the operation and maintenance of the structure. They can't deny access to the project sponsor. They can't undertake activities that would impair the purpose of the project sponsor. They can't do activities that may damage parts of the structure, its appurtenances, those types of things. And they can't allow others to come in and do any of that. So you want to make sure that they're aware of some of the things they can't do. Now, for those of you that aren't online and can't see my next screen, it is a picture of a flood retarding structure, and it has a beautiful little dock that goes out to the principal spillway tower. And we've got a landowner that's put a beautiful slide and diving board out on the principal spillway tower. And these are some of the problems that, of course, you come up with in regards to what can a landowner do, what can they not do. And I can tell you that until this happened, we would have never thought to tell a landowner that you can't put a diving board and a slide on a principal spillway tower. Let's talk a little bit, though, about what a landowner can do under an easement. And, you know, they can impose, the original landowner can impose reasonable restrictions on the district's point of access to the structure. And even subsequent landowners can try to discuss and negotiate where they would like your access to be, where it should be located, whether or not it's one that you use just for inspections, but they'd like you to use a different access point if you're coming in with heavy equipment to do some kind of major repairs or rehabilitation. They can also utilize the area around the structure as long as it doesn't impair the use of that structure. So an example of that might be that they're going to run cattle, flash graze around the structure, and they can do that so long as they're not creating cattle trails and damaging the structure. They can utilize the structure in a reasonable manner in ways that both the project sponsor and the landowner can agree upon. Before you grant specific rights to a landowner on an easement, you need to think long-term about who might want the same benefits and about the ramifications. And this comes up sometimes. We had a situation with irrigation where a landowner wanted to open the floodgate on the principal spillway tower and be able to open that and run water out and be able to irrigate downstream. Well, there is some natural wear and tear when they do that. There's some ramifications that come about with that. And then once that landowner leaves, is that something that you're going to allow subsequent landowners to also do? And is there anything that needs to be discussed specifically on wear and tear and other issues that need to be addressed? So project sponsors need to be thinking about these things when they're dealing with landowners. Let's talk a little bit about successors and interest. Of course, these are the people who succeed to the original landowner's interest in the property, and there are generally two types. You usually either inherit the land or you purchase the land. And so I want to talk a little bit about some of the problems that arise with easements. And for those of you that can't see my next slide, I have an outlet pipe, and it's full of rattlesnakes. So it's a good example of some problems that will arise. This one, of course, would be during an inspection. But I'm going to talk more about easement problems. So with the development of rural areas in which a floodwater retarding structure is located, that is starting to create more problems. As rural areas grow, more people move in, and of course, one of those major issues is access issues. Sometimes they will outright deny access. You can't come in here. They try to lock the gates. They try to limit how you can access the property, and some of their requests are reasonable. Can you call and give us notice that you're going to be out there? It's limited, but it's something that we should do and try to do to be a good neighbor. And the other thing is in regards to access, you know, sometimes it's an education of sitting down with the landowner and explaining the easement and the access. And sometimes what we've even done is we've even amended the easement to specifically state where those where our access point would be. And that clears it up for all future successors in interest. Some use issues. There we've had some objections to maintenance, and I put the word rehabilitation over there to the right. This is something that has come up mostly by attorneys when we're getting ready to rehab a structure, and it's all in the use of language. So you may hear this argument if you go and say we're going to rehabilitate the structure. We get the word rehabilitation from a federal program where we can go and seek federal funding to help us rehabilitate a dam. Usually in Oklahoma, it's due to downstream development where a low hazard dam is going to have to be made to meet the specs for a high hazard dam. And the confusion that arises for a lot of attorneys is they look at the easement and they say it says operation and maintenance. It doesn't say anything about rehabilitation, and rehabilitation must be something different. And it's all in the language, but that is something that we've run across. We have been able to, we've got an Oklahoma Supreme Court case that's kind of clarified all those issues for us, and we have clarified that through some statutory changes. Constructive or silent agreement to uses by prior landowners. Again, this is kind of getting into where you allow a landowner to do something and it comes into play, and you think, well, it's just for him. But if others know that he's doing that, you could set a precedence, and then all of them after him may say, well, we want to be able to do that. Or landowners that have a flood control structure on their site may also want to do some of those uses. So you need to really think before you grant special privileges. Did I go the wrong? Okay. The next thing I wanted to talk about was enforcement of easements. And when a project sponsor has an easement, it is accepting the responsibility to protect and care for it for a very long time, because most of those easements are, of course, permanent and perpetual. There are three components to easement enforcement. One, of course, is preventing violations from occurring in the first place. That one, I think, is the most important by far. Number two is having the ability to deal with a proposal to change an easement's restrictions. So when I talked about being able to go and do an addendum to an easement to maybe set out where your access is going to be, you've got to be able to have the ability to do that. And of course, having the means to enforce the restrictions of the easements when violations occur. So let's talk a little bit about prevention. Preventing violations from occurring, of course, should be your first objective. It begins with careful thought, especially if you're starting out with a new water retention structure and you're going out to get new easements, then you definitely want to think out what that easement should say. Every easement is different, so you want to look at what kind of issues could come up, what you should maybe be looking at addressing. Try not to leave anything to chance. There's no way that you can cover everything, but there are certain topics that you could cover. For one would be where they can locate structures, what they need to do if they wanted to put a dock in, what's the process when they're wanting to do something around the flood control structure. There's some language that I think could be very beneficial if you think about it ahead of time, and then you could add it into a new easement. Also, you need to be meticulous and consistent and timely in monitoring your easements and your records. And I would also encourage you to allow easy access to the flood control or flood water retention information, especially to the landowners. I know that in Oklahoma, we have landowners that say, well, I don't know anything about the easement. They'll call the project sponsor, and most of our project sponsors have those easements in their office, and they can pull it, they can scan it and send them a copy, they can put it on the copier and hand it to the landowner if they come in. And that is actually very beneficial to the landowner, because it's a little more complicated than that if they have to learn how to go into the land records and try to find those easements on their own. So another thing is just being able to have, I'm not too many. Yes, there it was. Changes and amendments. So being able to propose changes to the easements, making sure that you're looking at those changes carefully, and that there are times that changes will be necessary, but I also warn you to be careful what they're asking for. I know that we have a couple of instances in the past, mostly done in the 70s, where we had some easements on some low hazard, significant hazard dams, and the landowner wanted to develop that property for housing and went to the district and asked them to reduce the easement back to an elevation, and the elevation that they picked has now had consequences for the project sponsor, because they're now having to update that dam to meet high hazard dam safety criteria, and it's really tight to do the work, and there's houses all around. And so those are things that as a project sponsor you want to be thinking about, trying to figure out how things might impact the future individuals that may have your job. Let's talk a little bit about legal remedies. So if there's a violation that does occur, the number one thing that you should always try to do is to negotiate or sit down with the landowner and try to work out a way to resolve the issue. If you can do that first, that can always save everybody in the end. When a violation occurs, that must be stopped though immediately. So for an example, we had a pipeline that never notified us, and they're already out there laying pipe and they're getting ready to plow through an auxiliary spillway. Then you can run to the court and ask for an injunction. It is a writ that is granted by the court, which requires someone to do something or refrain from doing something. So in the instance of the pipeline being laid, we would be asking them to stop doing what they're doing, and then we can sit down with them and figure out what everyone needs to do from there. If you have to go to court, be prepared. If you have documented the easement history, if you have copies of notes, conversations, then that's going to help you later on in any case that may arise. Going to court, it really should be the last resort. It is usually an expensive proposition, and it can ruin the partnership created between the landowner and the easement holder, the project sponsor. So we definitely know that we have the ability to enforce the easement, but how do you do it and still try to keep a working relationship with the landowner? One of the things I always tell districts, of course, is that the landowner can do anything with that land so long as it doesn't interfere with the operation and maintenance of the structure. But what actually is interference? And interference with an easement is a form of trespass. So therefore, a landowner can interfere with the purpose and use, and the project sponsor can seek a legal remedy against a landowner for that unlawful interference. Courts, based on the case studies, they frequently enjoin the obstruction of an easement and order the removal of encroaching structures, for example, at the landowner's expense. Now, if it's a chicken house, the court may weigh that a little differently, because that may not change, it does not change the hazard classification of the structure. But if they were to put a house there, then that's something definitely that the court will look at. An easement holder also is entitled to protections from acts of third parties that interfere with the enjoyment and purpose of the easement. So when the landowner for the flood control structure allowed the pipeline company, because he got paid to put that, to get that pipeline to go across his property, he's allowing that third party to come in and put that in, that's also interfering with our structure. And so that would be an example of a third party that's interfering where they should not. Now I want to talk a little bit about some things that you can do to kind of limit future problems with your easements. And some of these will seem very common sense, but these are lessons learned. So number one, make certain your easements are recorded at the courthouse. I was telling you a lot of our easements are old. They were in the 40s, 50s, 60s, and I can tell you that we have come across some that the landowner signed it, everything was ready to go, and they never filed it at the courthouse. So you definitely want to make sure that your easements are recorded. You want to make sure that the easement documents have the correct name of the grantor or landowner. Sometimes that's hard to do if they're older easements, but I can tell you that we've had some easements that have been granted and that person was not the owner of the land. And so those are things that are always good to check if you are able. You want to spell out what's agreed upon in the easement, spell out what's unacceptable uses, spell out the terms of access, and then you need to meet your obligations. If you say you're going to call the landowner before you go out and do an inspection, call the landowner. If you tell the landowner that you're going to be out there doing work, then make sure that you keep him informed and you're letting him know and you're not taking advantage of the situation. If you're a landowner, you want the person that has an easement across your property to keep you informed, let you know, and have a good communication. So keep up with who the landowners are. You know, the land can change hands. You want to make sure that you know who the landowners are. You want to inform the landowners of the important issues. One of those important issues may be about oil and gas lines coming in. I find that if you have a good working relationship with a landowner, they usually hear about things earlier than you do as a project sponsor, and they'll come in and they'll say, hey, I just heard from ABC Wind Energy Company and they're wanting to come out and put wind turbines out here. Well, that allows you as a project sponsor to know that you probably also need to contact AB Wind Energy Company to make sure that there's not going to be any issues with what they're wanting to do with your water retention structure. You want to inform new owners about the structures and the easement. You would be surprised how many new owners get in there and they don't realize that there's an easement on the property and that there's things that they should or shouldn't do. And so you definitely want to educate them about that, and you want to educate them about what the structure actually is. This is the dam, and this is the berms for the spillway, and this is what an auxiliary spillway is, and this is what a principal spillway is, and explaining those things, because I've had many conversations with individuals that are owners of structures, and they don't know what all those structures are and what they do and why it's important that there's certain things that they can and can't do. And then you need to keep records of what you do and say. So those are all just some pointers that will help you in limiting future problems. The next topic I want to talk about is performing operation and maintenance. Before you go out and head out to your water retention structure where you have an easement, then you want to check your easement to make sure that everything looks okay. And before you go out there, you want to make sure you have an easement that has been properly filed, which we talked about. Verify that the current landowner knows about the easement and that you know what's in your easement, if there's any special requirements. Some of our conservation districts in Oklahoma have 100+ flood control structures that they're taking care of and looking after. And some of them may have specific things that they need to do in their easements. And so they just need to make sure that they're on top of that before they go out and do any O&M. Some other easement problems I wanted to talk about. Like I said, a lot of our easements are old, and we have some that were from the Bureau of Indian Affairs because they were dealing with Indian lands. And some of the problems that we've had with the BIA records is that a lot of them are not always recorded at the county land records office. And so they're really hard to find. If you don't have them in your records, it is extremely hard to find them in the BIA records. A lot of them were just easements that were granted for a 50-year term. And what we have found is that they've expired, and it is quite a process to get new easements for a flood control structure that's already there through the BIA process. In Oklahoma, there can be multiple owners. And you've got to notify as many of them as you can, and they may have a 0.0000064% interest, and you've got to try to get 51% to agree to the easement terms. And then another one that we have, of course, is school lands or commissioners of the land office. And when we got a lot of our older easements, they did not charge state entities. And when those limitations on the easements have expired, then it's no longer free to state entities, and there's an application process. And so you may have something similar in your states, and those are things that you just need to be aware of and make sure that you're checking to make sure your easements haven't expired. Some other things to know about easements is there's a general rule on prior easements. So there's a priority. It's usually first in time, senior versus junior easements. And this has come about when we've had to rehabilitate a dam and there was a water line, for example, that ran on one side of the dam. We're getting to rehab that dam. That line's going to have to be moved. Well, the water line owners and the project sponsors are going to have to go back and look at their easements, and whoever's easement is the oldest, the first in time, they have priority. And so the one that is junior, in this instance, let's say it's the water line, then they're going to have to go and move that line at their own cost. And so that's the general rule on priority and easements. Another issue that has come up, I don't know if it's unique to Oklahoma, but it is definitely can be challenging, is in some of the old easements, they may make an easement line along the middle of a creek. Well, what happens then if the creek moves and it's no longer in the area that it was once in when you first originally wrote those easements? And so you definitely want to always think about your legal descriptions and make sure that they stand over time. I briefly talked about release of easements earlier, and I kind of want to specify that more for everyone. So a release of easement is where you're going to surrender the rights or interest in the property. So if you're the easement holder, you're saying, I no longer need this easement, I'm going to release it. And the only entity or person that has the right to release it is the holder. So that would be the project sponsor. And the release will have to be in writing. It'll need to be signed by the person or the entity releasing it, and it also needs to be filed at the courthouse. We're getting close to the end, so I wanted to just point out some basics. Just always remember that what we're talking about here today is, just a quick review of some property law, but know that property law can be complex, and that disputes between landowners and project sponsors may require legal assistance. And so don't be afraid to try to go and find some legal assistance when needed. Project sponsors should avoid giving legal advice to landowners. Sometimes you can really get in a bind when you're the one out there trying to give legal advice to landowners. I would try to avoid that. Project sponsors should refrain from getting involved in property disputes and issues. I find that landowners really would love to get a governmental entity involved if they can, to come in and talk about water issues and fencing issues between them and their neighbors. And so it's always good advice to not get involved in those. Lastly, I just wanted to point out a few things. I have just kind of listed a bunch of different things, but the couple of areas I wanted to point out was, number one, our Cottonwood Creek 54. For those of you that might be interested, that is an Oklahoma Supreme Court case that came out of a rehabilitation in Logan County, Oklahoma. And if you're interested in reading that case, it's Logan County Conservation District versus Pleasant Oaks Homeowners Association. And it was filed on June 7th of 2016. And the case number is 2016 OK65. And that decision focuses a lot on easement issues, on taking, whether there was a taking, and whether or not the dropping of the water in the instance for this flood control structure resulted in a taking. And of course, the court came back and ruled in the favor of the project sponsor. In this case, being relatively new has been really helpful as we've moved on with other projects in the state of Oklahoma. Another issue that has come up is water quality issues. I don't know how it is in your state, but in Oklahoma, we have a provision in our statutes that says that the water quality in our flood control structures is not an issue for the project sponsors, because the project sponsors don't have the ability to control what happens on the land of the landowner. So if there's things running off the land into the flood control structure causing water quality issues, there's no way that the project sponsor can cure that problem, short of suing the landowner and trying to get them to clean up. Maybe they've over fertilized or whatever the issue is. And so Oklahoma has clarified that issue. Also, we've had several issues where houses have been built below a flood control structure that was not a high hazard structure. I listed Logan and Stevens beside this listing. Stevens County is one where we had 2 homes that were moved in below the dam, and the district had to contact their DA and work to get those houses removed. And Logan County is an ongoing case that we have going on in Oklahoma right now. Auxiliary spillways, we have a lot of things that come up with violations in the auxiliary spillway, whether it's somebody planting a garden, somebody wanting to run their pigs in there, or trying to lower the spillway so they get a dozer and plow through it because they want water to flow earlier so it won't affect their cabin that they just built. So there's lots of different issues that we have come up dealing with auxiliary spillways. And then we have 2 issues that we are dealing with in regards to principal spillway towers. So in Oklahoma, the landowner has the right to sell the water in our retention structures, but that has led to a problem where they want to go in and cover the principal spillway tower with something so that the water won't go through the tower and the structure will hold more water. And so that has been a problem that we continually fight in Oklahoma. And then recently we've had 5 structures where cement has been poured down the principal spillway tower, and the landowner was trying to close that off. And so there's lots of different examples that I could go over, but hopefully that gives you a little brief summary. And I'm going to go ahead and conclude it there and then take any questions.
Well, thanks so much, Janet. And I know with that much said and that much to offer, you probably have a need to go get that bottled water or a cup of coffee or something. But I've got a great deal of questions here ready to present to you. So if I could start with one question then. Are you all set?
I'm set.
Okay, if the project sponsors want to release their easement, does the land have to go back to what the land was before the water retention structure was built?
That is a good question. And that's usually what the general rule is that it would have to go back to the way it was before the water retention structure was there. And that would definitely be something that would have to be worked out with the landowner. So if the landowner said, no, I want you to leave what's there, but I want to be the owner now, then you would have the option of being able to go in and release that easement.
Okay, speaking of releases of easements, if an easement is released, who is responsible for the works of improvement?
Well, that is a good question. So I would argue, at least as far as it goes in Oklahoma, the landowner would then be responsible because he would be taking that on. One of the tricky things that I see with release of easement is that you can release an easement without the landowner knowing that you're doing so, at least in Oklahoma, but I would expect that you would get sued if you left and released the easement and left them with a bunch of responsibilities that they weren't aware that they were getting. So I think that being I'm going to say a good neighbor, and that is definitely issues that would have to be worked out before you ever went and released an easement.
Well, speaking of releases, this seems to be another question that came in, Janet, for you. Federal interest has expired. How do you deal with sponsors who no longer are active, nor have they made a request to dissolve the easement?
That's a good question. We haven't really run across that yet too much. Most of our project sponsors are conservation districts, and we have a division in the Oklahoma Conservation Commission that's there to help support them, to help them with operation and maintenance, taking care of those dams and trying to help them through each of these issues. So I don't know that I have a specific answer because I have not seen that.
Sure. I'm going to reach out and phone a friend. Dan, if you're on the line, and John, if you're on the line and want to unmute, tackle that one. Federal interest expired. How do you deal with the sponsors with no longer are active or not made a request? Dan? Give you a break, Janet.
Well, we've actually dealt with that in several states, and it has varying degrees of unpleasantness in terms of addressing the problem. But one of the things that sometimes the easement holders don't realize is that the easement holder is the entity. It's not the individual signees, the individual people who served on the board, say in 1962, that signed that. The easement holders are the current sitting board. Sometimes people get on water improvement boards or conservation district boards, and they don't realize that responsibility is one they've taken on as a board member. So I think it kind of depends on, on which of the partners is asking the question. But I think you have to educate the easement holders and demonstrate to them why it is in their best interest to stay engaged, whether they become vulnerable to lawsuits for damages because they're not fulfilling their obligations and responsibilities under the easements, or they expose themselves to some risk or liability because they are no longer maintaining the structure in a safe manner, and the public is maybe turned it into an attractive nuisance. There are just lots of reasons that you don't want to walk away, or that you can't walk away. So it's occurred, and it requires some sponsor education and some cooperation with our NRCS brothers and sisters to maintain that stream of benefits that the structure produces.
So I guess best advice for a board member, watershed group or district or conservation district, find out where the sites are where you've got some risk and liability as an entity, huh? And maybe go see them and certainly get some information about what the agreement says, huh? Would that be good advice?
Yeah, inspection is protection, and as Janet pointed out, really the inspection should start back in the office with the review of the easements and the documentation in place that clarifies the nature of the relationships between the sponsoring entities, the landowners, and so on and so forth.
Mm-hmm. Well, stay on the line, Dan, and Janet, we're going to unmute you again too. I see you muted. Let's go to the next question. Sponsors often ask in regard to structures where the federal interest has been met. They are beyond their evaluated life, for example, and can they release the easement to the owner? Is this a difficult or costly process to release the easement to the owner when the federal interest has been met? Janet, Dan?
I haven't actually dealt with one of those. I do know, talking to NRCS, that it is kind of a lengthy process. Dan, do you have any knowledge or experience in that?
A little bit. And for those of you of the 166 people listening that know me, recognize that I'm a little bit of a smart aleck on occasion, but I cannot imagine in my wildest dreams why a landowner would want to accept the total responsibility for a structure. But in fact, we do have folks that want to do that, and I actually think that's taken place in a place or two. However, the thing that happens there is it's not just a simple transfer of responsibility, because there is an entity somewhere that has regulatory authority, a state dam safety agency, that will in fact be notified that that mantle of responsibility is being transferred. And therein lies the problem for the private landowner that wants all that back. It's really quite a load to take on as far as the regulatory community goes.
Well, thanks so
I
much,
agree.
Janet. And
Yeah, I was going to agree with him that I don't know why anybody would want to take on those legal responsibilities.
the short answer is don't do it if you can't, if you don't have to, huh?
Yes.
All right. Let's go to a couple of short questions here, but very timely.
Hey,
And appreciate
Ray?
you all sending in your questions. Yes, please.
Let me add something to that.
Yeah, Dave.
The end of life whole question and realization of federal benefits are not legal questions. Those are somewhat manufactured economic evaluations, and so you shouldn't mix those up with the legal aspects of the site and the liability aspects of the site. The end of realizing the federal benefits is simply a calculation that says, hey, we got out of this what we put into it. So you need to be cautious and not get those mixed up together and think that somehow end of life, end of design life, and so on and so forth is some sort of a legal declaration that has some legal standing.
Oh, so legal standing remains on even if the federal nexus was satisfied.
Correct.
I got it. Well, here's one, and we'll stick with this release of easement for just a bit here. Who has the, if the easement is released, who does the liability fall upon? I think you may have answered that. Let's though repeat that answer.
Well, if you release the easement, and I'm going to say this and qualify it with, it's mutually agreed to by the landowner and the easement holder who's releasing it. And once it's released, the easement holder no longer has any rights on that property. And you'd want to specify in the release of easement that you've talked to the owner and those types of issues have been resolved, then it would fall on the landowner.
All right, thanks so much. Let's go to the next question. How are districts supposed to pay legal costs for protecting the easements?
This is John Devlin. I can probably address that.
Ready?
Most governmental entities or governmental subdivisions have access to some kind of insurance. In South Carolina, we have a state entity that provides insurance to governmental entities. And if it were not for that insurance, there's no way that the little watershed district that I represented for 10 years would have ever been able to pay for that litigation. So if you do not have, if you are in charge of a watershed district and you don't have insurance, you need to ask somebody uphill of you, somebody in the local Department of Natural Resources. What do I do about getting some liability insurance? It's not expensive and it will save your bacon if a bad problem comes along.
Another good advice for board members of a board that may have an easement of some kind or a structure of some kind to take care of. Make sure that they've got the appropriate liability insurance and other insurances needed, huh, John?
Yes, sir.
Okay.
And Ray, I'd like to add one thing for those that are listening from Oklahoma conservation districts.
Yeah.
What many conservation districts in Oklahoma don't realize is that in our statutes, they have legal counsel, and it is the DA for the county in which they reside. And if the DA doesn't feel like he can handle it, they also can ask the Attorney General's office to address those issues. And if for some reason neither one of those can, then they would have to look at some kind of way of getting a private attorney.
And we
But
recognize
right now, the issues that we have going on pending right now, we have the DA involved on one, and we've got the Attorney General's office involved in 2 others. So just for those out there that are listening from Oklahoma.
So Oklahoma specific, and while it might mirror in your state, well, we got 39 states on, right? So it might mirror in your state, but we want to make sure that you check your state's folks. Contact your state conservation agency or other entity that could help you sort that out, huh? Would be our recommendation. Is that correct?
Yes.
Okay, thanks so much. Who owns the water in the reservoir on a structure like this?
I think this is another question that's going to depend on each state, but Oklahoma has specifically put statutory language in regards to water quality. And then we also have addressed the issue that the water itself is the landowner's water, and they can use that water so long as it meets what we have in Oklahoma, which is the Oklahoma Water Resources Board, which deals with the sale and use of water. And as long as they're complying with that, they have a right to sell that water. The district or the project sponsor does retain the right to drain that water, to do operation and repairs. And by draining that water, there's no taking involved. But I don't know how that is in other states. I know that's how Oklahoma has addressed it.
Probably different in each state. So check with your state water supply or water agency regarding that. Here's an interesting question regarding title companies. Do you know if there has been a precedent begun of title companies not going back far enough in time to find the publicly owned easements that are related to a land when a land sells or transfers? Has there been a precedent?
I haven't had a problem with title companies not going back far enough, but we definitely have a problem with utilities and energy companies that are running their own titles, and they do not go back far enough. And so the next thing I know, they're plowing through with their pipeline or their transmission line or building a wind turbine, and they've had no communication with the project sponsors about the easement and the structure. And it's because they didn't go back far enough. And that's something that we're trying to educate constantly all of the energy companies that come in about where our structures are, where they can get that information so that they have it in their files, who they need to contact. So it is a constant thing.
Take a quick break here just for a bit. I'm going to answer one question on your behalf. Will these slides be available after the presentation? Certainly the recording will be. Dan, will you be posting the slides up through the presentation on the National Watershed Coalition website?
Yes, sir. We'll have the slides and the audio up, and you can view them and utilize them there.
That sounds great. Thanks so much. All right, back to some tougher questions. That was a real easy one. Could one of you talk about, define or explain what a blanket easement is and how it functions? What is a blanket easement and how does it function?
Are they talking about a block easement?
Well, it said blanket in the question, so not quite sure. Blanket easement? Maybe it is block easement.
Janet, I believe they are talking about a block easement as opposed to one delineated by elevation.
Okay. Well, in Oklahoma, what they did when they went out to get their flood control structures is they didn't know exactly how big they were going to be because they were building so many of them so quickly, so fast, that they went and they got what we call a block easement. So they might say, we're going to get the whole southeast quarter of the northwest quarter, and we're going to build that structure on that quarter. So that's called a block easement. So they can be really large. And so landowners, when they get their whole quarter section is covered by an easement, they do want to contact project sponsors and tried to reduce that easement many times. So that's kind of what a block easement is. They're pretty big blocks of land that have got an easement on them.
Okay, thanks so much. All right. If a sponsor does not maintain the works of improvement, is the sponsor in violation of the easement? What is the landowner's recourse if the sponsor does not maintain the works of improvement?
This is John. I think that the operation and maintenance agreement would speak to that rather than the easement itself, because all of the sponsors will have signed on to one of those O&M agreements that obligate them to conduct regular inspections and to perform regular maintenance. And if they fail to do that, I think that they would have some liability under that agreement.
And who would be liable for that then, John?
Whatever entity is the sponsor, whether it's a watershed district or a county or a Department of Natural Resources in South Carolina, whoever the sponsors are.
Whoever the sponsor is. So really important to know about that, what the sponsors are. Let's talk about a dam that's slated for rehabilitation that requires a wider spillway, additional easement. The landowner doesn't want to agree with the wider spillway, the larger easement. How do you proceed with something like that?
That one is a tough one. We have, of course, tried to either purchase the land either through fee simple or as an easement, but if they have determined that they just do not want it, unfortunately, here we have had to use eminent domain, which nobody likes, but it is necessary for us to be able to comply with the Oklahoma Dam Safety Act. And so that's the tool that we have used.
It's a kind of a last resort, is it, Janet, or is it something that would be needed?
It is a last resort. We try not to take anything in eminent domain if we don't have to, but we've had to do it several times.
Okay, so you've actually
another way that might work is depending on the language in the easement, because the easement that I was most familiar with, the language in it that allowed the easement holder to do whatever they needed with regard to construction, operation, maintenance, and inspection of the dam. And if you can argue that in order to maintain the dam under current circumstances, you've got to widen the spillway, then you would have an argument that what you're doing is covered under your original easement, assuming that you're staying within the boundaries of the easement.
Right. And that's where that Supreme Court case is that we have that kind of addresses that same issue. But where we don't have an easement, which we've also had that situation, we've had to resort to eminent domain.
That's very important. And I think Janet spoke to this earlier, and that was make darn sure you get some legal help if you get into that situation, or you working with a sponsor that gets into that situation. I remember that very well. Get some legal help, huh, Janet?
Yes, absolutely. Absolutely. I find that project sponsors, sometimes they need some guidance because some of these issues can get complicated. So I would definitely push them towards some kind of legal counsel.
John, we're going to go on here for another 5 minutes, and then I'm going to turn it over to you for your presentation too, and take some more questions. We're going to get to as many questions as we can, but let's take this one on. What would the state be responsible for works of improvement if the original sponsorship is dissolved?
Well, that's a good question. The state is not an entity listed on the easement, so it usually sits with the project sponsors. I don't know. Dan, do you have any thoughts on that?
Well, sooner or later, somebody that is pursuing that issue is going to come back to what I would call a parent agency or some entity up the food chain that has oversight for the previous sponsor. I said I wasn't going to tell any lawyer jokes today, but that would probably be a question that would have to be resolved on a case-by-case basis in the specific state where it was occurring. The old saying being, anybody that's got $50 and a map to the courthouse can sue anybody. But with some research, somebody's going to come up with an entity that is responsible if the original sponsors are gone, and who that is probably would vary, as I said earlier, by each case.
Yes, because I don't see any connection other than like, for instance, the Oklahoma Conservation Commission, we assist conservation districts, but we're not on the easements. We're not signees on the operation and maintenance agreements between the project sponsors and the USDA NRCS. So I definitely think, though, that if that happened, that's something that as an entity that helps those districts, we would all be looking at and trying to see what might happen. I could see where we might move that structure to another conservation district to take over the operation and maintenance. That's a possibility. We've had some districts that have consolidated and taken on structures from the old districts. So that's another possibility.
Thanks so much, Janet. Thanks, Dan. How do you handle when you have an easement that doesn't explicitly say access is allowed and the landowner doesn't want to give access?
Ray, could you repeat that? I'm sorry.
Yeah, this is a situation, hypothetical, I assume. How do you handle it when you have an easement that doesn't explicitly say access is allowed and landowner doesn't want to give that access?
This is John. My guess would be that you're going to have to tell the landowner that if necessary, you'll go to court to get that right, because any easement is going to carry with it the obligation to maintain it. And you would tell the judge on behalf of the easement holder, Judge, we've got to be able to maintain it. We've got to go, cut the grass. We've got to go bush hog it. But we can't if Mr. Smith won't let us over his property. And I think a court is going to be sympathetic to the easement holder in that situation.
Thanks, John. We appreciate it. Again, we got a couple more minutes here. We're going to take some more questions as we go along, get to as many as we can. So this is in regards to releasing an easement. Is there a typical fee associated with releasing an easement? Or can a sponsor legally release it to a property owner at no cost to them? So this is in regard to costs associated with releasing an easement.
The releases of easements that I've seen done, and a lot of the release of easements that we've done have dealt with block easements that were acquired, but no flood control structure was ever built there. And then the district would go and release that easement. There's never been any monetary cost to that, other than possibly, depending what your state is, if you had to go and file that release of easement at the courthouse, there could be a cost to that. Now in Oklahoma, there's another statute that says that conservation districts, when they get copies or they file something at the courthouse, that they're not supposed to be charged for it. So depending on your state law, it could vary, but you could have a cost for filing that release.
State law dependent, huh? And in that regard, maybe even be county dependent. I'm not sure, huh? So certainly. All right. Historically, there be a fee associated with release of easement. This is similar to what we just talked about. Does a landowner a fee associated with a release, survey, recording, or even the fair market value of the property being released? So again, anything to add to that last response, Dan, John, about a fee associated with the release of an easement?
No.
I can see a different topic coming out of that question. in regards to, there was a structure that we decommissioned, and we could not put the land back into the same state it was before the flood control structure was there. The land was soggy, it was not really usable, and we did work out settlement agreements with the landowners and did pay them for that property, and over a set number of years on how long we thought it would be before it would dry it out and it could be usable. And so we did do some release of easements, but we also did pay the landowner for the property.
Mm-hmm. And costs involved, huh? Mm-hmm.
That's correct.
Okay, work that right out with the landowner as was needed then. Okay, thanks, Janet. All right. Does a release of permanent easement have to be a mutual agreement between all the entities involved?
The answer to that is it should be. But, and I don't know how it works in other states, but in Oklahoma, you could go and file a release of easement and not tell anybody, but you could have legal ramifications if you did that. And if you left them out there hanging with issues on their property. So I would definitely encourage anybody who's looking at wanting to release an easement to look at several things. Number one, what's their responsibilities under their agreements with the feds? And then also, you know, what kind of liabilities would they be leaving with that landowner? And what is their policy in regards to the future operation and maintenance of those structures? I mean, I think they need to look at everything before they decide that they're going to release an easement.
Do all you can to hopefully get that resolved. That seems like a good launching off period. John, we want to make sure that we get to your presentation today. And it's my honor to introduce John Devlin on, again, easement basics and a successful easement defense in South Carolina. And John has had some experience in that arena. John, we welcome you today and thank you for joining in on the questions responses here so far, and we expect probably some more. So encouraging the folks to ask the questions on their questions dashboard. John Devlin, please.
Thanks. This is the first time I've ever given a virtual presentation. I've been giving talks of one sort or another for most of my life, but this is the first time I've not been able to see or hear my audience, which is a little different for me. So I'm going to assume that all of you out there listening to this are sitting on the edge of your chairs in rapt attention, hanging on every word that I say. In turn, y'all should assume that you can visualize me as a cross between Gregory Peck in To Kill a Mockingbird and Matthew McConaughey in A Time to Kill. If you check my website and you decide to bring up as a question, wouldn't it be true that it's closer to Joe Pesci and My Cousin Vinny? You're a damn liar. Okay, so let's just leave it with the illusion. This is not the first time I've given this presentation. If you were unfortunate enough to be present when I did this in Nebraska City, Nebraska, in September of 17, there won't be a whole lot new here. You have my permission to play solitaire or check your email. And lastly, before I get started, I noticed from one of the lists I saw of attendees that we've got a fairly strong presence from the state of Texas. I was in San Antonio last year and was quite taken with the river district there. In Greenville, South Carolina, where I live and practice law, we have a river that runs through the middle of town. And when the city fathers were thinking about trying to rehabilitate that part of town, first thing they did was take a group out to San Antonio to see what it looked like out there and see how y'all had done that. And so thank you, San Antonians, for the positive influence you've had on Greenville, South Carolina. I've been trying cases here in Greenville since 1983. A lot of it's been for the various governmental liability, governmental entities, the highway department, the county, and starting in 1995, I began representing an entity called the Raven Creek Watershed Conservation District, And primarily the reason I'm here today is because in the course of that litigation, I've learned a pretty fair amount about how these easements work or don't work, and some of the pitfalls that can come along with it. And as I think we've already discussed, the law on this will vary from state to state. Property rights law is a very state-specific area. What applies in South Carolina may not work in Oklahoma. There may be a statutory overlay that we don't have. So if you ever run into a question about the enforceability of an easement that you're charged with maintaining, check with a lawyer. Go find somebody and say, where do I go find a lawyer who's not going to kill me with his fees to talk about this? Who knows? You may have, like Janet was saying, a DA or an attorney general type whose job it is to help you. Okay, y'all may see now the first of my screens on my PowerPoint, which is an easement for construction and impoundment. This was the seminal document in the Raven Creek watershed case. And if you look at it and you start reading it, you will understand why the litigation lasted as long as it did. It was a form easement that was created, we think, in perhaps the 1940s by, we think, a federal employee from maybe the Soil Conservation Service. It was used with regard to a PL 566 program dam that was being built in the southern part of Greenville County in order to reduce the impact of flooding down there and further towards the coast. And what happened was the word got out in the mid 1970s that one of these dams was going to get built. And this very clever developer, a guy named Dr. John Burry, decided he was going to go find out where that easement was going to be and where the lake was going to go, and he's going to buy up all the land. And he bought acres and acres. I want to say, 80 or 100 acres that he figured was going to be lakefront property sooner or later. And after he bought it, the folks from, I believe at that point it would have been the Soil Conservation Service and the Raven Creek Watershed District came to him and said, we need to get an easement over this property. And he was happy to do it. And somebody typed up the document you see there is my first exhibit. And on the second page, they signed it. And also accompanying that easement was a sketch map that's the third of my slides. And I'll be referring to that a little bit more. That was part and parcel of the litigation that we had. Now, if you go back to the first slide, please.
All right.
You'll see the operative language that I've highlighted. Dr. John Burry does hereby grant unto Raven Creek an easement upon, over and upon the following 6 or 8 lines of legal, and then track number 34 shown on a sketch map of Raven Creek watershed. And that map you just saw a glimpse of is that sketch map. And go on down to the highlight part there. For or in connection with the construction of a floodwater retarding structure for the flowage of waters in, over, upon, or through such structure, permanent storage, temporary detention of any waters that are impounded by that structure. Now, if you know what to look for in that easement, you can look at it and go, so they're building floodwater retarding structure. They're building a dam, and they want the right for flowage in, over, upon, or through the dam. But you can't read this document and tell how far that easement goes. What elevation does it go? What properties does it impact? What this impacts is property owned by John Burry as shown in that sketch map. So you flip over to that sketch map. If you did that for me, Ray, one more, there you go. And that's the document that the lawyers who were handling closings had to interpret to figure out whether or not an lot was in the within the easement. The highlit line is one of the boundaries of the easement. It's the 724.5 top of dam elevation. It's kind of hard to look at this particular sketch map and figure out exactly where that line runs. You can only tell where the dam is if you blow this thing up enough to see down on the bottom right-hand side, more or less, the line that says dam, the itty bitty letters. You see the crosshatch above that where the borrow area is. Y'all know what a borrow area is. That's where they took all the dirt to build the dam. Unfortunately, after the dam got built out of that dirt from that borrow area, John Burry started having homes built right up that line where the borrow area is. He had one home built right smack dab in the middle of what was the borrow pit. And a lot of it was unfortunately beneath the elevation of 724.5. And flip on over, if you would, Ray, to the pictures that we have here. The first picture, that, ladies and gentlemen, is a fellow named Steve McConnell. His house behind him is the closest to the dam. This picture was taken on the front page of the paper a couple of days after the flood and went back down. I always picture Mr. McConnell as going, how did my property flood like that? And a careful observer will look back and see that long, flattish structure behind him. He is standing at the 700-foot elevation at the normal pool level, right next to a dam that rises 24 feet above the normal pool level. And they knew that when they built that house, and nobody caught that easement gave us the right to flood up to, over, and through the top of dam. This is being recorded, so I shouldn't say it, but it was a lawyering failure. Careful lawyers would have stopped when they got to that sketch map and said, in all probability, I don't have any idea what in the hell this is talking about, but I guess I could hire me a surveyor who could find out, and a surveyor would have been able to tell you that Mr. McConnell's land was heavily impacted by our easement. And if you flip to the next slide, you can see again Mr. McConnell's property on the hard right, and in the middle, a blue structure that is John Lopresti's house. And you'll notice how flat the land is between his house and the edge of the lake. There's not a whole lot of rise there. And in the summer of 1986, when Tropical Storm Jerry came through Georgia and camped out over the weekend in upstate South Carolina, it dropped 20 inches of rain on us in 2 days. And that's what Mr. Lopresti's house looked like after the 20 inches of rain. Waterfront property, y'all, not what he wanted. We started getting lawsuits about a month after that. August, to be about September or October of 95, Mr. McConnell sued. All of his neighbors filed suit thereafter. We ended up defending 4, 5, 6 landowner suits. They sued the developer, Dr. Berg. They sued the engineers. They sued the builders, and they sure sued the Raven Creek Watershed Conservation District. Their primary theory against Raven Creek was that we had a duty to warn landowners when we saw those houses being built, and that by not advising them of the existence of our easement, that we were prevented from enforcing it and liable for damages. Now, I'm a trial lawyer. You know, I grew up sort of doing car wrecks and things like that, and I didn't do a whole lot of property closings. But I remembered what my property professor said in law school, which is an easement that's properly recorded in the chain of title is notice to all the world of the terms that it contains. And that was my argument every time I opened my mouth and went to court from 1996 till 2010. We had recorded as it turns out, according to the Court of Appeals, an unambiguous and clear easement. It gave us the right to run water not only up to the emergency spillway level, which is as high as it got, but even higher to the top of dam level and over the top of dam. And one by one, those lawsuits were, as to Raven Creek, dismissed. Other folks had to pay some money, Dr. Burry most notably. But we didn't pay a nickel because we hadn't done anything wrong. Now, briefly, what could we have done different to avoid 15 years of litigation? Because y'all, I like it when a client gives me 15 years of litigation, but if you're the client, you don't. The first thing is your easement, if you're a watershed district, is the seminal document. It's the United States Constitution. It's the Magna Carta. Know where it is, know what it says. If it is one like I have, and you're stuck with the terms of it, know what the terms of it are. People misunderstood what our easement said. I had to explain to my watershed district sometimes what it said. And I don't know how much these days people are still going out and obtaining easements for floodwater structures, but if you are, make sure you know what land you're going to impact and make sure you get an easement that covers all of that land up to the area that the water might cover. Don't use a sketch map like we did. If you are able to give a meets and bounds description of the property impacted, better. I think one of the things that made it difficult for us is the judge who first heard our case looked at that easement, and he was not a property lawyer either. Scratched his head and said, I have no idea what this says. And he saw all of those poor benighted homeowners that were well and truly screwed, y'all. They took the short end of the stick because they built houses and bought property that was gonna flood. And he felt real sorry for them. A good easement is going to describe what you can do. And the question that got asked a little earlier about access is a good example. It's going to say, and I believe ours did, that we have a right of access for maintenance. It's going to describe what the landowner can do. If you go back to that first screen at the very bottom, we had a single paragraph that said there's reserved to the grantor the right to use the above described land, his land, for any purpose not inconsistent with the full use and enjoyment by the grantee, that's the easement holder you, of the rights and privileges herein granted. Now, quick, tell me what that means. Yeah, we had to say we have the right to flood, and you have the right to do anything that's not inconsistent with our right to store water and let it out and temporarily or permanently detain it. Y'all saw on the slide that had that had both McConnell and the Lopresti pictures on it that Mr. Lopresti had a little boat shed right out near the water. There you go. That is a violation of the easement because in a hard flood, that could pick up and move. And if that picks up and moves, or if you've got a bunch of stuff in your yard, like a boat trailer, like a bunch of kayaks, something like that, all of which can move in a flood, and it moves and it goes over to the temporary spillway and it blocks the temporary spillway, now you got yourself a new problem. So the rigorous enforcement of your rights means you're not going to let people build things that are within the easement. If it hasn't happened yet, if people are asking for permission to build, what we ended up coming upon was we told the county, We would not think that it would be inconsistent with our rights as the easement holder if you built and did not have any finished floor elevation below the top of dam. And so we told those people 724.5 is our top of dam. We won't complain and maybe ask for the removal of a house which has as its first living area floor 725 or more. The judge in our case said, you should have gone back and let them know. Y'all saw houses being built. As a judge, we gave them notice. We told the whole wide world in 1976. And the judge wasn't buying any of that because sure enough, my folks, the sponsors, the Raven Creek Watershed District, they would go out sometimes and do these inspections. And they saw houses going up. There's testimony. And they didn't go over and knock on anybody's door and say, hey, you know, there's an easement. I argued that was superfluous. They didn't need to. And legally, they didn't. They might have saved themselves some trouble if they had. And after this flood came, it became the policy of the Department of Natural Resources, which assists all of these watershed districts, to periodically check the title around these watershed lakes and give notice to people at the various properties that there's an easement affecting their property. And it doesn't change anything, but it at least allows them to do a little planning. We mentioned a little bit earlier when Janet was talking about O&M obligations. Y'all are probably familiar with those operation and maintenance agreements. Those got a very glancing treatment in my case, but I was scared of them because you're taking on obligations to do things out there, which if you don't do them, or if you don't do them regularly, or if you don't do them well, can create liability for you. In our case, one of the big factors, which legally was insignificant, but practically bit us in the butt real bad, was that there were annual inspections of the dam that had to be done. And we had this very helpful guy who was in the NRCS, who would come up once a year and he'd sort of drop by and say, hey, I'm getting ready to go do the inspection. And he'd go get in his little John boat and ride around and look at the side of the dam and walk up on it and look for sinkholes and look for trees and that kind of thing. And come back, fill out his report, and he'd get the Raven Creek guy to sign the report saying that he'd been on the inspection, but he hadn't. And those lawyers on the other side of that case were so quick to call that fraud and misrepresentation, and it didn't have anything to do with the fact that they had bought property inside an easement. But it was a problem for us. It created a duty that if we had carried it out and if we had maybe gone the extra mile, could have helped some of these folks. The best preventive maintenance you can have, other than conscientiously following your O&M obligations, is if you don't have insurance, get it. 20 years ago, when I started this case, I was charging the state of South Carolina $80 an hour for my time. A lot more than that now. And with me and the appellate lawyer that I had and the associate that I had to bring into it and the 3 appeals and 2 trials that we had, we went from September of 95 to February of 2010, one way or the other. And it would have been impossible for that little watershed district, which didn't even have a budget, y'all, to fund any of that. I don't know how much the total tab was. $150,000, $200,000. It'd be a lot more now. But if you don't get anything else out of today's talk, go back to whatever office you have and say, hey, if somebody sued us, who would take care of that for us? And don't stop till you get the answer, because after you get the papers, it's a little late. And finally, I need to give credit to, and the people aren't here now, but they were material to me at the time. We had with the NRCS here in South Carolina, a engineer named Grady Adkins, who had started his career with the Soil Conservation Service and had actually been one of the designers of the dam in question. And he was a material amount of help to me in understanding how the dam worked, what the theory was, why they got the easements the way they did. He was my Sherpa. And we had with the South Carolina Department of Natural Resources, a guy named Leslie Morgan, who was sort of the big brother for all of the watershed conservation districts. And he performed some kind of magic that I didn't ask any questions about that caused the state of South Carolina to provide us coverage where I do not believe any existed, so that we had an insurance policy backing us up. If you are sponsoring one of these dams now and the lake size doesn't prohibit it, you can give notice to current owners. They might know, they might not. It's not a bad idea. It might just create a problem, though, when I think about it, because if I've already bought that house you're looking at right now, and somebody tells me, oh, by the way, we can flood this up to about 8 feet into your main living area, I'd turn around and start looking for somebody to sue. But I just want to throw a couple of attaboys out there to the NRCS and the South Carolina Department of Natural Resources, without which I wouldn't be having this talk right now because I've never been in that case. If you want a full recitation of the facts of the case, I pulled it up while I was getting ready for this. There are about 3 different opinions, but the one that does the best job of explaining what happened is called Binkley, Binkley versus Raven Creek Watershed Conservation District. It's a 2001 South Carolina Court of Appeals case, 348 South Carolina 58. You can get my contact information, call me if you have any questions if something comes up. I certainly missed a marketing opportunity when I didn't make my card a part of my PowerPoint presentation. But that's about what I have. Who's got a question?
Well, people interested, certainly, John, we can get that information to them if you're willing to share, and you can send your card to me and I'll make sure that I get it to the folks that want it. The first question came in, as you were speaking, that I want to just go to first. In the South Carolina case, did the court hold that the easement encumbered the entire 172 acres called out in the deed?
The easement encumbered, no, it did not encumber 172 acres. If there is a part of that PowerPoint with the sketch map on it, and I'm not sure if, no, I didn't even copy that part of the sketch map, but in the sketch map, it references that there's like 56 acres within the easement. 172 acres that they're referring to is all of the tract 34 that belonged to John Burry, I believe. And that tract 34 is, if you're looking at the land rights work map, the third of my PowerPoint slides, it's the one on the far right side where the borrow area is. So that's the tract that he bought.
All right.
Only part of which was in the easement.
One of our individuals said you would add the errors and omissions insurance for board members as well. Excellent idea, huh?
What we had was not called errors and omissions. It could be a directors and officers policy, maybe. This is just a general liability policy for, I guess, tort claims. But the state was very generous and interpreted it in favor of the watershed.
All right. Going to go back here a little bit, pick up some of the questions that came in a little earlier too. So if willing, Janet and Dan, you might want to join John on this. what can you do when the original 1950s or 1960s county commissioners signed an easement to provide funds only for the structure, and then the current commissioners court doesn't want to provide funds or claims that previous commissioners court cannot obligate county funds for future commissioner courts? So again, probably a state specific question here, but any response to that would be appreciated. Back in the 50s, 60s, a county commissioner's court obligated themselves, right? And then now the current one doesn't want to have anything to do with it. So thoughts?
Ooh, my view of that would be as long as that watershed district or county commission or whatever entity it is going to remain as the holder of the easement, the grantee of the easement, then they have to maintain the easement. The Horn Book law is that if you have an easement, it's up to you to maintain it. And if you say, well, they can't bind me, well, they can't force you to spend particular amounts of money. But I think that if you're going to say, I'm not going to maintain that easement, then you're probably going to have to abandon it if you can. And I'm real curious how, if the easement is still functioning in holding back floodwater, how you abandon it and leave it to the landowners. I don't know how. I certainly, like we talked about earlier, would not accept that burden if I'm a landowner.
Yeah, especially if it's impounding water to boot. That one is. And just a note here, John and Janet, if a group wants to contact you afterwards, would you be willing to receive an email from somebody that really got into some specifics?
Sure.
Okay, thanks, John. Janet, thanks so much. Dan, same, I hope, huh?
Absolutely.
Okay, so here's one right from Texas. You mentioned Texas, John, a little bit earlier. An attorney for the Collin County, Texas Commissioners Court has determined they no longer have operation and maintenance responsibility after 50-year economic lifespan, even though the operation and maintenance agreement is perpetual. They believe that they are no longer sponsors. The Conservation District needs help getting them to fulfill their obligations. Kind of a follow-up to that last scenario that was lifted to you. You got, again, a county court, county folks, let's see. Yep, county commissioners determined they no longer have an O&M responsibility after 50 years lifespan, a perpetual agreement in the operation and maintenance. Help us out with that, John. What do you think?
Well, I think when a judge says I no longer have responsibility, that I could probably rely on that. But if I'm a landowner, and I mean, what if I'm a downstream landowner and I look up at that dam upstream of my house and I see that it's got ruts in it, it's got cattle tracks in it, and there are oak trees growing in it. And I'll look around and see who's supposed to be maintaining that. And the county commission has abandoned it. They've said, we have no responsibility because it's year 50. Well, when that dam gives way and floods me off of my property, and that's downstream property that's not burdened by the easement, I'm probably looking for somebody to sue. I don't think you give up your liability by saying that you're giving up your obligation to maintain. I think the liability lasts as long as the dam does.
Say what you want, but the legal part of it may be different than you just saying it and trying to get out of something, huh?
Yep. You bought yourself a land right back in the 1950s.
Mm-hmm.
And what you're saying is, I refuse to maintain that land.
Mm-hmm.
But that land is running across other people's land, and I think the law says you have an obligation to maintain it. So check with a lawyer in your state as to how that's manageable. And if you can, fine, maybe there's legislation out there about that. But the first thing I would think is that obligation to maintain that runs with an easement is going to cause you some difficulty.
Got a question here about any of the presenters have experience with filing a notice of easement to refresh an easement in the property records that is more than 50 years old to increase the likelihood that it will be found in the title searches done by folks and even by the energy companies and others doing some digging and whatnot. Do you have any experience with filing a notice of easement to refresh the easement?
I'll
I
defer to
don't
Jan.
have it. We've never done that in Oklahoma. I know it's something that we've talked about, and there's been legislative committees to look at, but it is not something that we have dealt with or actually done. Dan, have you heard of anybody doing that?
Not specifically in Oklahoma. I do know that there are some areas in Texas where there was quite a bit of oil and gas play, and I believe some sponsors did go ahead and bring their easement records up to speed, or I guess you might say double check them with the land records at the courthouse, so that some of the hundreds of landmen that are going through those records, it would jump out. I also know of districts that have furnished GIS information to some of the county offices, so that as folks start to go through the land records for whatever purpose, that map tips them off that they probably need to look at certain parcels for easements.
So a refresh of the GIS data set would be one thing. John, anything to add to what Janet and Dan gave us?
No, but I was thinking when we were talking earlier about the fact that some of these easements are getting to be 50 years old, that if I could figure out a way to refile it legally, I would. Problem is that theoretically the easement has to be signed by both the grantor and the grantee. And you might have some difficulty getting folks to re-up. If they think they have a choice, they might say, no, I don't want to do that.
Okay. Re-up. Okay, got it. Thanks so much for the question. Thanks for the response. What measures should a sponsor consider if they have a dam where the housing development has occurred upstream below the top of the dam? What measures should a sponsor consider if they have a dam where housing development has occurred upstream below the top of the dam? Any thoughts on that one?
Well, that's basically what happened to me, what happened to Raiden Creek. And really the best you can do is go out there and do an inspection, figure out how high into some of these properties your easement goes. There may be some places where there's danger to life and limb. And if you find a house that's so far into your easement that a flood could kill somebody, you need to tell them that that house is a danger and probably ask for it to be condemned. That's harsh, but you have that land right and you don't want to be in a wrongful death lawsuit down the road. I would, if you know there's a housing project that impinges on your easement, I'd let everybody in that housing development that I knew was within my top of dam elevation know, here's a copy of our easement. It runs to X elevation, and we've determined that all or part of your property is within that. These are your obligations under the easement. You can't do this and you can't do that. And in a flood, you are liable to have your yard and or house impacted.
Thank you, John. Let's switch gears a bit here. Who is responsible for negotiating the terms of a price for an easement when the project funding is not from the district itself?
My understanding is that most of these easements are at nominal consideration. The theory being that the landowners who are giving an easement that's going to allow a lake to get built, look at it and go, well, that's going to improve the value of my property, so it's in my interest to make sure it happens. Although I did hear stories from the older commissioners about different landowners who are holding out for $500 or $1,000 that they would have to rustle up from one of the sponsors or another.
Mhm.
I'll follow up just briefly on that too, in that, for instance, negotiation of new easements or additional land that we need to take by easement that a conservation district needs to do a rehab. A lot of their funding comes from the state. And so most of that negotiation is done in partnership between the Oklahoma Conservation Commission and the project sponsor.
All right, thanks,
And
Janet.
I'd also point out, Ray, that that varies widely from state to state. If you're in an area where there is oil and gas operation going on, and people are hearing everything from leases going for $275 an acre up to $8,000 an acre, when people start hearing easements and so on, they get all kinds of dollar figures in their mind. So it may depend on where you are. If you're in the oil and gas area, you know, you may sure hit a snag if there's been a lot of land rights activity going on in that area. If you're in an area where that's not a big deal, you know, you may still get an easement on a handshake, or you know, in exchange for a dollar and other goods and services, something like that.
We're bumping up against our 2-hour time here, but in the spirit of making sure that we don't leave a question unanswered, are you willing to stay with us, Janet and John and Dan, for a little while longer? Take on some of
Sure.
these questions? Okay.
Absolutely.
Sure.
Dan, this is your call too. Are you all right with this?
Yeah, I'm good.
All right. What does the panel think about the idea that sponsors periodically send out mailers to owners in the watershed with basic information about the watershed, including the purposes, the easements, and the operation and maintenance?
I find that to be extremely helpful. We do have conservation districts and other project sponsors that do send out periodically letters kind of updating landowners on the issues. And we also have some that will hold meetings at their district offices and have like a meal and do presentations with the landowners, educating them about the structures.
Mm-hmm. And as we change our way of doing business here for a little while, we hope that that becomes a norm again, that we could have meetings with them and maybe even make it a less formal kind of thing with a barbecue and so forth, huh? That's what you said?
Yes.
Mm-hmm. Good way to go. Meet your neighbors, good fences, all that sort of thing. There's a book on that, I think. In regards to re-recording an easement deed, can you simply re-record the copy of the existing easement deed, regardless of the recording date, and just put a note on the cover page stating this easement is being re-recorded to prevent it from being lost in a chain of title? Back to the re-recording for just a bit.
I am not aware of that procedure applying in Oklahoma. I would love to know if we could do that. Does anybody know or about other states?
I'm with you, Janet. I'm not aware of that procedure. That said, if I wanted to do that, the first thing I would do would be to go to the local, here we call it the Register of Deeds, and sit down with whoever the head person is and say, I've got this 1967 easement and I want to re-record it to save people a bunch of trouble. And it has been my experience that all of those Register of Deeds offices are little kingdoms unto themselves, and they'll have different rules. Some will let you, some will say, oh no. Some will say yes, but you have to file it in triplicate. You never can tell. But I don't know of anything that says you can't re-record an easement. I guess the question would be if, like with mine, the one grantor in 1976 has now conveyed out all of that property to where there are 15 different people. Do you record it in all of those chains of title? And is that a valid recordation? You would have to ask a better land rights lawyer than me that. There are a lot of them.
So, and related to that, this question comes in about the easement elevation issues as monuments and elevations are updated. Have sponsors ever needed to update an easement elevation?
Not in my experience. And that would be because the amount of the elevation we needed our easement to go to was dictated by the height of the dam. And the height of the dam wasn't changing.
Mhm.
And so
But if you
once we
rehab
knew-
a dam, sometimes you have to raise the height of the dam. And so I could see where you might have to get more easement if the height of the dam raises the easement area beyond what you have an easement for. And
I
that
agree.
would, of course, be an elevation easement that you're looking at. So,
And my comment on that, which has been one for a long, long time, is that in the initial stages of rehabilitation planning and looking at what can be done, a sponsor probably should emphasize to NRCS that the rehab job should go on within the footprint of the existing structure and impounded water, and if at all possible, stay within the boundaries of the existing easement. That's an easier starting place than finding out you need to get 15 more acres someplace and you've got 4 landowners on 15 acres or whatever. So in the planning process, probably need to think about that up front. How can we do this and stay within the footprint of what we have now, both easement wise and structurally?
Thanks, Dan. Appreciate it. Let's talk about solar power energy company wants to build solar panels within the easement of the watershed. Staying with this idea, does the easement prevent this?
the easement does not prevent it if it doesn't interfere with the operation and maintenance of the structure. So depending on where they were going to put it, if it's not going to impact the functioning of the dam, then the landowner would be able to put those out. There's also a possibility that if it were like a low hazard dam and they built it and it wasn't in the way when it was low hazard, but you have to rehab it and bring it up to high hazard, then it would be up to the solar company to move any of the items that they have that would be in the way on the easement.
Okay, very good. Follow up on that Commissioner Court's question. The Commissioner's Court was only one of the sponsors. So all sponsors would have to be involved in that decision apparently, huh? All right, that's just a clarification. So here's a note. As a sponsor, can we fence the boundaries of an easement to prevent encroachment or trespass?
I'm not sure that well, first of all, your easement, the kind of easement that I'm familiar with, sort of coexists with the rights of the people who own the fee underneath it. It would be impossible for the Raven Creek folks to have fenced the boundary of the easement without fencing people out of their property, because everything beneath the elevation of 724.5 was within the easement, and some of that was owned by private landowners. So could you fence the dam itself? Yeah, I think you can fence and gate the dam to prevent damage to it, because that's probably not owned by anybody individually. But to the extent that you've got an easement over somebody's property, as opposed to owning some part of it, like the lake bed in fee simple, I think that's going to be a problem.
I agree.
Okay, thanks. All right. Commissioners are not required to provide funds for emergency medical service, fire departments, libraries, child protective services, etc. either. It's just the right thing to do. So just a note from, and I'll send that along. to everyone. So they've all got that note from the one individual that sent it to us. Thanks. Have any sponsors acquired title to the lands within the easements for the prevention or trespass of modification? So kind of a follow-up to that fence and other things. Have any sponsors acquired title to the lands within the easements for the prevention and trespass modifications?
I know
I
that that's
don't-
one of the. Go ahead, Janet.
I was just gonna say, I haven't ever seen that happen or occur. The only time I've ever really seen a project sponsor own title in fee simple is either because they were going to also include municipal water supply as a purpose of that flood control structure, or two, they acquired it through eminent domain. But I haven't
Right.
seen it used in that circumstance.
Yeah, if the sponsor has fee title to the property, the need for the easement kind of goes away as long as there's a document in place that shows that the express purpose of owning it is to facilitate the installation or operation and maintenance of the upstream flood control structure.
Right.
Purpose of O&M. All right, got it.
Y'all, I'm gonna have to drop off now.
Okay. Well, John,
I've got-
I sure appreciate it. We left off with just a couple of questions left here. And I think we will go ahead and do our closing comments. But if you do want to follow up, either contact myself, I can put you in contact with the speakers, or also the other option is to go and contact Dan. So with John about ready to get off, I know we want to express our appreciation to Dan, to Janet, to John in regards to all of the information they provided us today. So I'm going to switch back over to Dan for some closing comments. Dan?
Thank you, Ray. I do want to thank John and Janet for taking the time to share some knowledge with us. I appreciate your work there at BoardWorks in making it all run smooth. Appreciate all the folks who jumped in on the webinar. Your time is valuable. We appreciate you spending some of that with us today. This will be up on the website, the NWC website. There are some contact information items available on the closing comment slide, and there is a contact slide up now that talks about our website, says where our Facebook page is. We would invite you to view the information there and utilize those resources. And I will give you a heads up that just down the road in July, there'll be another NWC webinar coming up on inspections. So stay tuned for that. Watch the website for the announcement, and we certainly appreciate you spending some of your time today with us. Thanks, Ray.
You bet, Dan. Again, Janet, John, Dan, thanks so much for providing this informational webinar from the National Watershed Coalition. Back out, and we had a high water mark today of 169 folks that joined us. And not only that, Dan, but there's 122 of them still left on the line as we close out our webinar today. Good day, folks. Stay safe and healthy out there. Take care.
Thank you.
Thank you, Ray.
Yeah, my pleasure.